Insofar as the information to be given to the suspect about the offence itself is concerned, there was a significant rollback from the original proposal. Originally, the information that was to be provided was a description of the circumstances in which the offence was committed, including the time, place, and degree of participation in the offence by the suspected or accused person, and the nature and legal classification of the offence. That unfortunately has been diluted to simply say that Member States shall ensure that suspects or accused persons who are arrested or detained are informed of the reasons for their arrest and detention, including the criminal act they are suspected or accused of having committed. There's clearly a significant dilution and reduction of the information that is required to be provided. Article 7 deals with the rights of access to the materials of the case. And this, I think, is one of the most important articles in the measure, and one which is likely to cause considerable difficulty in certain member states. In my member state, for instance, when I attend at a police station to advise a client, I will be informed of the nature of the offence which is under investigation, but I will not be informed of the evidence which is held tending to connect the detained person with that offence. That information is only made available to me typically after a charge has been preferred and when there has been an appearance in court. The absence of this information makes it very difficult to advise somebody in custody, particularly in our jurisdiction where inferences can be drawn from their silence or from their failure to mention material facts. I had obviously hoped that when Measure B was under discussion, that we would have, as many continental colleagues have, the opportunity to examine the case file during detention. The measure does not go that far and is heavily circumscribed by reference to national law. What you are now going to be entitled to is access to the materials of the case with a view to challenging effectively the lawfulness of the arrest or the detention. This clearly doesn't go as far as being given the entire evidence which would enable you to make a decision as to how you would approach the decision whether or not to make a statement while in custody. However, at a later stage that information will be available, and in Article 7.2, Member States shall ensure that access is granted at least to all material evidence in the possession of the competent authorities, whether for or against suspects or accused persons, to those persons or their lawyers in order to safeguard the fairness of the proceedings and to prepare the defence. In subparagraph 3, without prejudice to paragraph 1, access to the materials referred to in paragraph 2 shall be granted in due time to allow the effective exercise of the rights of the defence, and at the latest upon submission of the merits of the accusation to the judgment of a court. Where further material evidence comes into the possession of the competent authorities, access shall be granted to it in due time to allow for it to be considered. There is, however, a derogation from Article 7, and that's in Article 7.4. By way of derogation from paragraphs 2 and 3, provided that this does not prejudice the right to a fair trial, access to certain materials may be refused if such access may lead to a serious threat to the life or the fundamental rights of another person, or if such refusal is strictly necessary to safeguard an important public interest, such as in cases where access could prejudice an ongoing investigation or seriously harm the national security of the Member State in which the criminal proceedings are instituted. Member States shall ensure that, in accordance with procedures in national law, a decision to refuse access to certain materials in accordance with this paragraph is taken by a judicial authority or is at least subject to judicial review. Now, again, I think this is a point where we can look at how the original proposal was actually far more effective and broad-reaching than this present proposal. In the original proposal, in the then Article 8, the decision to withhold information could only be a judicial decision. There was no question that it could be a decision made by the police authorities and reviewed subsequently, as the present Article 7 envisages. It had to be prior authorised by a judicial authority. And I think we would all, on the defence side, take the view that that is far preferable. The temptation for the authorities to withhold information and then ex post facto to justify that to a tribunal is entirely unsatisfactory and creates a temptation to bend, if not break, the rights of detained persons. Under new Article 8, it is provided by way of verification and remedies that Member States shall ensure that when information is provided to suspects or accused persons in accordance with Articles 3 to 6, this is noted using the recording procedure specified in the law concerned, full stop. The reference to there being an effective remedy is removed, and instead there is a reference to a right to challenge. Now, I'm not entirely sure why this change came about, but I know that the phrase effective remedy is a phrase that would give great comfort to defence lawyers, but the phrase a right to challenge is a phrase that is absent any concrete guarantee and simply indicates that there should be a forum at which concerns can be ventilated, even if that forum does not have the authority to take meaningful steps in relation to it. Effective remedy was understood to refer, in some of the discussions, to an exclusionary rule in relation to evidence unlawfully or unfairly obtained. That is a rule that applies in my jurisdiction, and it is, in my view, a very effective deterrent against abuse of police authority. And a remedy that falls short of that is unlikely to be as effective, and a remedy that is not even described as an effective remedy is almost certainly going to be short of the standard that we would wish. Originally, in Article 7, when they talked of the right of access to the case file, the language was far more robust. Consider the following terminology, which no longer is part of this measure. Member States shall ensure that an accused person or his lawyer is granted access to the case file once the investigation of the criminal offence is concluded. Access to certain documents contained in the case file may be refused by a competent judicial authority, where access to these documents may lead to serious risk to the life of another person or may seriously harm the internal security of the Member State in which the proceedings take place. Where it is in the interest of justice, the accused person or his lawyer may request an index of the documents contained in the case file. In Article 8, 2, in the old measure, or the old proposal, Member States shall ensure that a suspected or accused person has an effective remedy in instances where he does not receive the information. Now let's pause and consider why this was diluted. And I think it was diluted because the Member States could not bear the suggestion that there would be a guarantee of access to the documentation, or as a minimum, an obligation for the authorities not only to identify all documents that existed, but to seek prior judicial clearance for withholding them, and to provide to the defence a real method of securing an effective remedy, namely, disclosing the existence of the documents and presumably justifying, document by document, why it should be that they would not be provided to the defence at the relevant stage, whether in the investigative phase or the trial phase. And unfortunately, it is a feature of the measure that it is telling where amendments have been proposed that they tend invariably to be contrary to the suspect and pro the police. And that is a matter to be regretted. Article 10 is a final article to discuss in any little detail, but again it shows the somewhat begrudging attitude of the authorities to guarantees. The original proposal in Article 10 was to the effect that nothing in this directive shall be construed as limiting or derogating from any of the rights and procedural safeguards that may be ensured under the European Convention of Human Rights, under the International Covenant for Civil and Political Rights, and under other relevant provisions of international law or the law of any member state which provides a higher level of protection. The new Article 10, the final version of it, provides for non-regression. Nothing in this directive should be construed as limiting or derogating from any of the rights or procedural safeguards that are ensured under the Charter, the ECHR, other relevant provisions of international law, or the law of any member state which provides a higher level of protection. The difference is that somebody, for some reason, has decided to take out the express reference to ICCPR. Why this would be done, to deny the validity of the principles in that measure, or otherwise, is a matter for debate. What it does show, however, is that very considerable thought has been given to amending this measure to reduce its effectiveness from the point of view of persons in custody and their advisors.